Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions. Presented by Wasinger Law Office. Join us as we unravel legal complexities and secure your family's legacy.
Hello and welcome. The topic is estate planning. Matt Wassinger is an estate planning attorney with Wasinger Law Office based in Orlando, Florida. Great to see you again, Matt.
Thanks for having me back.
I know you were based in Orlando, but how far does your reach go?
Well, we've actually done estate plans kind of all over the state, but typically we focus in the Orlando and surrounding areas. So Seminole County, Orange County, Osceola County, but College Park, Winter Park, Delaney Park, those areas right around where our office is based tends to be where we're most active.
I recently read a statistic that says 56% of Americans believe estate planning is important, but only 33% of adults in the U.S. have actually documented their end-of-life plan. What are your concerns when you hear a statistic like that?
Well, I mean, the biggest concern is just people are kicking the can down the road, right? They're just assuming that they've got time. And that's the one thing that we all assume, especially the younger we are. And what our firm tries to point out is everyone needs an estate plan. It doesn't matter what age you are. And the longer you wait, the worse off it is for your family, because that's the only thing you can do once you're gone to kind of have some sort of help, control, however you want to look at it, to make sure that your family is taken care of, is by putting something in place. And I think the more that we can point that out to people is when we see people coming in with more of a goal to get it done, as opposed to, I'll just get to it.
Is there usually a trigger that brings them in?
Unfortunately, most of the time it's because they've just lived through going through a probate for someone else that they know that has passed. Right. So they're a parent or grandparent or somebody that they've had to live through that process, puts them in a position to know, okay, I don't want to do this and I don't want my family to have to do this again. And that's normally one of the biggest factors. Our firm tries to focus on people with young kids because they tend to think they don't need it. And that's the people that need it the most, because if you want your minor kids to go to the people that you believe will raise them the best, not the people that may look best on paper to a judge. And if you are worried about your kids getting any sort of lump sum money the second they turn 18, then that's when you have to worry about estate planning, because that's the only way you can make sure that there are guardrails or milestones in place for them to be able to get to where you want them to be, or at least have the ability to get there by setting up an estate plan that focuses on that.
And from your perspective, what are some of the biggest myths in regard to estate planning?
Well, one is definitely that if you've got at least a DIY will set up, you're not going to probate. The other is that, I've got my kids or my spouse or whomever, my partner, on my accounts, so everything is fine. Well, those are the situations where if something happens to your spouse or your kids or someone else on those accounts before you, then you're right back to where you were. The other thing is that opens up your assets to liability for those other people. So a lot of people like to put their kids on their account. Well, if their kids go get in trouble, and most of the time trouble is a car accident that sends people to the hospital, they're at risk of their accounts being garnished if there's something, if it becomes a lawsuit that goes against their kids. So there's holes to that. The other thing people seem to think is my will direct where everything goes, but they have their beneficiary designation, say on their life estate or their life insurance, going to somebody else. Well, the beneficiary designations overrule your will. So if you put, at some point, you've got a life insurance policy, which happens all the time. Someone puts, let's say they just put their kids down, but they really wanted it to go to their wife, and their will says everything goes to their wife. Well, their kid's getting that life insurance policy. It'll override whatever's in that will. It stays out of probate at that point and goes to, unless the child is a minor, then it's going back to whomever the guardian is at that point. But those are some of the biggest myths there.
It sounds like the purpose of a will is much smaller than I think a lot of us thought.
Yeah, it's really just a playbook for people to follow. I mean, and I've mentioned in the past that judges ultimately try to follow the wishes of the person that they've outlined in the will. But sometimes the law, for instance, the beneficiary designations, or just circumstances that come with being in a public arena where people show up and claim all sorts of different stuff, dictates that things happen differently. It is very easy for someone to show up and, maybe an old business partner or an old acquaintance that says, oh, wait, he owed me 10 grand and this was supposed to go to me. Now, that might be a complete lie, but if they forge the paperwork, which does happen, the judge still has to listen to them. Even if they find it all to be beyond the pale, they'll still have to go through the process. And ultimately, the judge has to do what's best interest of what he can see or she can see. And that doesn't always go with what the will has set out.
So what is probate and why do we want to avoid it?
Probate is essentially a lawsuit against yourself, right? You pass away and let's think of a will, having a will or no will is holding all of your assets in your arms. You fall down, something happens to you, it goes everywhere. You have to go to court for a judge to find out what you have, what you owe, and who gets what. And again, they'll use the will in a lot of cases, but not always. And what you find out is the celebrities you hear about going through probate, that's because they didn't set up an estate plan. Aretha Franklin was one of the more famous ones more recently. She had 4 different wills show up in court, 4 different wills. And I don't think any of them were signed. Maybe one of them was signed, but they were still fighting years later because now a judge has to look at all of this stuff. All right, where is everything? Which one of these is the one we should follow and who gets what? And that can go on for long periods of time. It's also incredibly expensive. So it's the general rule we try to give is take about 4.5% of your gross estate, and that's what you're going to pay in attorney's fees for probate. And that's because probate is based on it's a statutory provision in Florida, which is a percentage of your estate. And there's the kind of a waterfall effect. So it's the same. They did that for it to be the same for every attorney. And you're not going to different attorneys getting all sorts of different numbers, but it's still very expensive. And just calculate that out and it'll be more than what you would want to pay, and significantly more than it would cost to set up foundational estate planning.
I've heard you use the word trust, putting it in trust or creating a trust. Help us understand the importance of that.
Well, so going back to the will, holding everything in your arms, a will does not skip probate. A will, you go to probate because a judge has to go find everything. A trust, we describe it as like one of those radio flyer red wagons. So instead of holding everything in your arms, you put something into the red wagon. And the revocable trust is what we're talking about for foundational planning, which you can take things in, put things in and take things out as you need to. You can amend it, you can change it. And when something happens to you, if everything is titled properly, which our firm tries to make sure happens, you fall down, your successor trustee just picks up the handle and keeps going. It stays out of probate, stays out of court, and what happens thereafter is what you've recommended happens. What you've set out in your estate plan happens. That's where it goes from there. And that's why a trust can be so beneficial, because not only does it skip that 4.5%, and remember, this is not just for wealthy people, because some people, if they have less assets, can't afford to have their assets locked up while people are trying to go through the probate process. This gets everyone what they need or access to what they need almost immediately with the trust being set up.
Probate can take a long time, as you mentioned.
Yeah, 12 to 18 months is kind of our general rule, but in Florida, we probably should start kicking out those figures a little longer, because Florida's there's a lot of people moving here. There's a lot of cases out there, and depending on how backed up the court system is, hearings can take 6 months to get on the docket, with a lot of stuff that has to happen in between. And that's if everything moves smoothly. So it can take some serious time to get through the probate process.
Everything's frozen until then?
Not necessarily everything, but depending on who was waiting on the will to give this to that or this to that person, it's going to take some time to get through. Houses are a perfect example. If the will says everything is going to the kids, but through the probate process, it takes them longer to get everything done and in the court system, and there's a mortgage on the property, the house could fall into foreclosure unless somebody's willing to start paying those bills or has the ability to, and they have to try to push along the probate process to get the house into the people's names that were named in the will, or the heirs that have stepped up and said, yeah, we want it, and then try to get it sold.
What is the first step in the process?
Well, if you're trying to avoid probate, the first step is coming in, getting something on the schedule so you can set up your estate plan and avoid all of these problems. And like we said, our goal is out of court and out of conflict. And out of court means skipping probate in any way that we can possible, and making sure that your family can handle everything privately without the cost and time and public nature of probate that can come with that.
I know we've touched on it a little bit, but help us understand again, why is just having a will not enough?
Well, it's important to point out that sometimes your goals are the most important thing, and a will may be enough for you, and your family. But if you're trying to avoid probate, a will on its own is not enough. If you are trying to make sure that maybe your minor children have at least some sort of guidance on how that money is left to them, and how it's spent down the road, a will is not enough. You can only do that with a trust. And if there are any extra protections that you want to put in, whether that is between your guardians and a successor trustee in terms of how your money is saved, prevented from future spouses getting a hold of it, or anybody, a will is not enough. It's always going to have to be a trust to have that control. Some people think that if they put it in their will, I don't want this money spent like this or that. They're relying on the hope that their guardians actually follow that, because basically it's just an instruction at that point. It's not a requirement. Whether there's a trustee, if they don't follow that, then they can get your heirs or somebody else can go have them removed and replaced. But there's a fiduciary responsibility that trustees have to follow, and their guidelines are part of the trust that you've set up, left for your minor children or your spouse or partner or whomever, that is going to keep track or keep guardrails and keep that those assets in place for them for long periods of time in the future, not just going immediately out to whomever the second something happens, or when your kids reach 18 years old.
There's a danger in that, turning 18 and perhaps coming into a large sum of money or property.
Absolutely. I mean, I tell all of my clients, I was probably better with my money than most kids when I was 18 years old, but I also would have bought a lot of stupid stuff. There would have been a lot of money just wasted that I would want back, as you get older, because you just don't know until you start having to pay all your bills and finding out how expensive life can be with taxes and insurance and everything else. And when you're 18, most kids are just barely seeing any of that stuff, if at all, depending on what their family life's like.
When people first contact you, there's a little bit of homework involved, but you make it a step-by-step process for them. So you try to make it easier?
Yeah. So we have a link. Once you book your appointment, we make you book your appointment first, and then we send you a link, because everyone we send the link or even a PDF copy that they can print out of the homework before something's scheduled. Never turn in their homework, so we never get anything scheduled. So we make you book, then you get a link, and then in the link you can complete everything online and save it as you go. You can attach your current estate documents or your account documents or your deeds and things within that, and then keep coming back to it to complete it. Really, in most cases, it doesn't take more than 30 to 45 minutes to get done if you just sit down and do it. But like everyone else, they try to push it off. So that's why we give the deadline and be able to, save and continue as you go.
Do you have any examples of cases that or clients that you've had where you've seen it work incredibly smoothly and not?
Oh, yeah. I mean, the easiest example is anytime someone passes and they didn't have their assets where they needed to, they come in and they have to go to probate, and they think everyone's on the same page until one person says, you know what, I disagree. It's not everyone's on the same page. You're getting different attorneys. You're fighting. It turns into very much like a divorce at that point, because they don't like how something went or think they deserve more or don't, a million different examples of that. But that's what everyone comes in and says, oh, yeah, we're all on the same page. And then somebody splits from that very easily. And it doesn't require a lot of money for people to start fighting. It is very, very small amounts in most cases. But the parts that work the best are when something happens, they've got a trust and their estate plan set up. They come in the office and say, what do we do? Say you take this to this place and you have all the documents here and you can have access to it right away. And you just give everyone what they need from that based on what the trust and the estate plan set out as. So it's a private, very easy meeting. I mean, there's some documents that your CPA or someone will need to file on the back end, but everything else is kind of at your own pace at that point. Whereas probate, you're either waiting on the judge or trying to force something to move as quickly as possible, but you're not in control of that process.
4.5% or 4% may not seem like a lot, but that's money that could be going to a loved one.
Absolutely. And, 4.5%, but you add that up. If you have a house, that adds up to about $20,000 pretty quickly, to give or take your cost of your house. And remember, it's on your gross worth. It's not your net worth. So they're not taking what you owe out of that. They're going after the entire amount. They're going off the entire amount. And most people have it. If they have a house, they have some sort of life insurance policy or retirement account, and you double that. You can get up to $20,000, $30,000, $40,000 very quickly. Whereas setting up your estate plan in most cases is going to cost you, only 10% of that number. You're saving, while it seems like it's more money than you'd want to spend now, it's significantly cheaper than the money you're going to spend later. I'm not including all the time and emotional energy it's going to take out of you.
Absolutely. Remind listeners the best way to connect with you.
The best way is always our website. We've got one-click schedule. We've got one-click call. And we've got plenty of information there for you if you're just trying to learn some more information before you set up a meeting. But the best way to get it moving and learn is to set up a family wealth planning session with us, which you can do right on our website at wasingerlawoffice.com.
Matt, thank you.
Thank you.
Matt Wassinger is an estate planning attorney with Wasinger Law Office based in Orlando, Florida. Please remember to like and subscribe.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one. And be sure to follow us on social media.